This cost assessment hearing is in the matter of case number CFI 29-2018 consolidated with CA006 and CA005 of year 2022 and is being held by way of video conference before Registrar Ayesha BinKalban. Any orders made during the course or at the conclusion of this cost assessment hearing will be made on the Registrar's instructions by the Registry. The claimant is represented by Ayesha, Middle East. Lead counsel is Mr. David True. The defendant is represented by Hamid bin Bahi, advocates and legal consultants. Lead counsel is Mr. Roger Bowden. Will the registrar and the parties' representatives please confirm that the situation is as I have stated? Thank you.
All right, gentlemen.
Good morning, Madam Registrar.
Good morning, Mr. Bowden.
Good morning, Madam Registrar.
Good morning. All right, sorry, I'm just having a bit of issues. All right, I can see you now, Mr. True. All right, so I'm in your hands, Mr. Bowden, Mr. True, as to how you'd like to take this assessment.
We've discussed between ourselves, and it's agreed that I should start. That's the way that it went at trial. Just a little bit of housekeeping. You may be aware that I've been having trouble accessing not just the audio-visual link, which is very kindly Shaheen has put us on Teams. But also the documents themselves on the system. But I have a offline copy of Mr. True's documents and of course an offline copy of my own documents in the order in which they were uploaded to the DIFC court system. And so I'm hoping that I can simply identify the document which I wish to go to in my bundle, or indeed if I'm referring to anything in Mr. True's bundle, mine are numbered and then the authorities are lettered, and hopefully we can do it that way. I won't know the internal page numbers, I'm sorry.
That's fine.
Sorry, I was slowed down because there's quite some feedback on the line at my end. Is that occurring for you too?
I don't have any feedback, but just in case, Mr. True, when Mr. Bowden is speaking, could you just mute your microphone if it's not already muted?
Absolutely, Madam Registrar, I will do.
Thank you.
Yeah.
Bowden,
At that moment, it seemed
with the documents, so you just need to refer to the name of the document and I'll be able to find it, so you don't need to worry about that.
Well, might I also inquire if you had an opportunity to read the documents? Okay, great. Well, and hopefully you'll hurry me along if I'm dallying on any document which you're well familiar with.
All right.
Sorry, I'm just coming back to the camera. If I'm spending time on a document which you fully understand and have seen, please indicate that, and we'll move to the next one. I'm hoping that we can chop through this. I would hope in an hour. Thank you. So with that, I'll take you, if I might, to the first, just whip through the initial documents. First of all, to our notice of commencement. So that's document 1 on the defendant's bundle of documents. Now, this is, and Mr. True very kindly didn't take any issue with this. This simply replaces the document which was filed on the 3rd of July. It's exactly the same numbers, and it's really a pro forma document. The next document is, of course, the invoice for that, which is 76,000 AED. We would be claiming that back in disbursement in the event that we're successful in this hearing. Document number 2, and I'm just going to page 1 of that now, and it's a document of some 14 pages. That is the consolidated bill of costs. It is reduced from that which was originally tendered, because we have reduced all of the rates to the DIFC rates. Okay, and so for the Hamdan Al Shamsi, the amount of 221,000 is sought. For Bindahi, 113,000. For myself, it's 532,000 reduced, and disbursements 146,000. Plus, we've also got that 76,000 we just seen, and that's a total of 1,014,381.97, and that is in dirhams. Thank you. I won't at this stage spend any more time going through the various bills. If my learned friend Mr. True wishes to come back to them, he is of course welcome to do so. What I would really like to approach first, Madam Registrar, is our points of dispute. That is document number 3, and it's headed 2023-07-24 Defendants' Points of Dispute. And it's an 8-page document. And really,
this is the defendant's points of dispute dated Monday, 24 July.
Correct. Thank you very much. Yeah, and I'm on page 1, and it's to the defendant. So these numbers, okay, so I'm at paragraph 1. These numbers, I don't think they're in any dispute at all. Mr. True will, I think, correct me, but the 159 gross figure and net figure, and the 92,000 for the Court of Appeal are the figures which are sought. So there's no dispute about those figures. We claim Mr. Fadil, who's not entitled to costs in the Court of Appeal, has filed a net claim for costs in the amount of 276,000, being 65% of the Bindahi and Arbelden costs, and 100% of the HAS costs. The difference between those is that the Bindahi and Bowden costs arose after the malicious prosecution claim had been filed. So in accordance with the decision of Justice Sir Richard Field dated the 10th of March, which we'll come to in a moment, we only get 65% of those. And this is really the crucial difference, is whether, well, our costs, we say, are to be assessed at the indemnity rate, and we say that Mr. True's costs are to be assessed at the standard rate, and that being the substantial difference between the parties here. So if I might, and I won't dwell on this, but I think it is very important, the legal basis underpinning the costs claims. So these 3 relevant cost decisions, I have to say I haven't put them in our bundle, but they are on the system and easily accessible. I trust that no difficulty to you. So, and it's very eloquently and aptly put by the Court of Appeal at paragraph 4 of the decision dated 30 November 22. In all the circumstances, the court awards TIG 2/3 of its cost in the appeals before this court, to be subject to detailed assessment by the registrar if not agreed. So, just regarding that first sentence, what the 2/3 relates to is it's not a standard award of costs, which it might be seen as, because standard award could be around the 2/3 mark. But what it is it reflects their measure of success. So if you were to go back to the Court of Appeal decisions, effectively TIG won 2/3 of its appeal and lost 1/3, and we didn't win any of our appeal. So therefore, the court said, well, 2/3 reflects your measure of success, and that to be subject to detailed assessment by the registrar if not agreed. In the court's judgment, that award properly reflects TIG's success on the appeal. No further adjustment is called for as to the precise times taken up. The court is additionally mindful of the observations as to TIG's conduct, not requiring further elaboration here. And we can see that what just below in the cost decision of His Honour Justice Richard Field, we see what that conduct is. So what I'm respectfully submitting in relation to the Court of Appeal cost decision is that they gave TIG 2/3 of its costs to be assessed by the registrar at the standard rate. There could be no argument that the Court of Appeal awarded TIG indemnity costs or 2/3 of indemnity costs. They most certainly, and that last sentence is a very clear indication that they were not awarding TIG indemnity costs less 1/3, reflecting its measure of success. They awarded standard costs at 2/3. Okay. Next is the cost decision of His Honour Sir Richard Field, dated 17 June 2022, and there it says, I'm of the opinion that the defendant, and strangely that's Mr. Fadil, is entitled to the reasonable costs he incurred in bringing his employment claim, including his successful opposition to the claimant's case that he had been dismissed for cause. His notice pay claim was for a sum calculated on the basis that his notice period was 90 days. The court rejected this claim, but awarded him a sum based on a notice period of 30 days. In this circumstance, I nonetheless think it's appropriate to award him his cost for this claim, which will be small, since he recovered an award based on 30 days and was overall a successful party on the other employment claims and on the dismissal of the cause. In my view, the aforementioned costs should be assessed on the indemnity basis. I say this because I regard the conduct of the claimant and HPA, they were called highly professional auditors, and they in fact turned out to be anything but. This later entity being the claimant's expert, in which the claimant attempted to have the defendant prosecuted for embezzlement, is highly reprehensible. And then His Honour went on and identified, I think, 8 elements of reprehensible behaviour, which we see in the next 2 sentences, 2 paragraphs. So I won't repeat all of that. But critically, at 18, in my opinion, the fact that there was no order for costs in respect of the ex parte application, I think we can actually skip through that too, sorry. The defendant has acted dishonestly. In my view, the evidence on how the defendant was treated by the claimant, who must accept responsibility for the conduct of HPA, was relevant to the dismissal with a cause issue at the time that it was also relevant to the defendant's tort claims. So what he's saying is that the indemnity costs which we have been awarded go across all claims, not for part of it, for all of it. And then 19, critically, in my judgment, the defendant must pay the reasonable cost of the claimant incurred in resisting the defendant's tort claims. So it's not reasonable and proportionate, it's reasonable only. It will therefore be for for the registrar to determine what these reasonable costs are and to set off the smaller of the sums that result from the assessment of the defendant's costs and the plaintiff's costs against the larger of the sum that results from these assessments. So, what he's saying is that in respect of all the matters which we succeeded, i.e. the claims upon which we succeeded and the defences upon which we succeeded, we get indemnity costs. In respect of the matters in respect of which the claimant succeeded, which was really only the defence of claims, they get standard costs. So thirdly, and here's the critical part really, the judgment with reasons dated the 10th of March 2023. By its order dated 17 June, Mr. Hamid was awarded his costs in respect of employment claims and the dismissal of cause issue, such costs to be the subject of detailed assessment on an indemnity basis by the registrar. And that neatly summarises everything that's gone before. For its part, TIG was awarded its reasonable costs in defending the tort claims, such costs to be the subject of detailed assessment on a standard basis by the registrar. And the Court of Appeal ordered on 30 November that TIG should be awarded 2/3 of its costs, subject to detailed assessment by the registrar if not agreed. And we've already, the Court of Appeal didn't expressly address the indemnity standard dichotomy. However, I think it's clear from their reference to the reprehensible behaviour that they were at the standard end. 24. Stepping back and considering the question against the background of 1, the extensive evidential overlap of evidence relating to the tort claims and the evidence relating to the dismissal of cause and indemnity costs, the very small amount of time taken up at trial and hearing submissions pertaining to the tort claims, the significance of the tort claims, the care and effort is to be inferred was spent by the team representing TIG, including in particular Mr. Montague Smith KC, in producing the claimant submissions. I conclude that the outer limit of the proportion of TIG's total reasonable costs represented by the costs in dealing with the tort claims is 35%. Now, precisely what costs are awarded to TIG in respect of their opposition to the tort claims within this parameter will be a matter for the registrar. Okay. So we have a differing view, right, as to what the result of the 3 cost decisions is. But we say that and so, yeah, we say that the result is this. TIG has been awarded at a maximum 35% of its costs on the CFI assessed on a standard basis. TIG has been awarded 2/3 of its costs on the Court of Appeal assessed on a standard basis. Mr. Fadil has been awarded 65% of his costs in the CFI assessed on an indemnity basis. Mr. Fadil has been awarded no costs in the Court of Appeal. So TIG's approach, TIG has adopted most but not all of the reasoning of the court of the cost judgments. TIG has calculated its appeal costs correctly at 2/3 of its actual costs, no issues taken with that. TIG has calculated its CFI costs at 35% of the CFI. It is not possible to tell from a cost narrative what percentage of the costs incurred were actually directed at the tort claims, and further information must be provided to determine that figure. Now, that hasn't been subsequently provided. So they've just taken effectively the same broad brush approach as we have and said, well, these are our total CFI costs. We want 35% of those. We don't quibble with that approach, other than to say that there's a further reduction on that 35 to bring you down from indemnity to standard. What TIG has not done in the calculation of its costs is apply the proportionality cost accorded to the award of standard costs. Standard costs between 60 and 70% of actual costs. Instead, TIG has applied the indemnity standard to that percentage of costs awarded, i.e. in the CFI it has been awarded up to 35% of the costs on a standard basis, but seeks 100% of that sum rather than 60 to 70%, which it's entitled to. And Mr. Fadil has approached the cost on the same legal basis as TIG, a minimum of entitlement of 65%, other than to say it's correctly implied that the indemnity standards. I do go into the rules about proportionality there and the basis and the difference in the basis of assessment. I think those can be taken as read. And what I would like to do is simply move down now to the table which sits at the top of page 7. And we say that this is the correct manner in which you should assess these costs. Indeed, if TIG were right in their argument, the answer would be that Mr. Fadil would be entitled to 100%, and maybe we'll come back to it when we look at Mr. True's reply submissions. But if TIG were correct in their argument, Mr. Fadil would get his gross costs in the CFI, which is 370,000. So what Mr. True has said in his reply submissions is that the 35% also reflects proportionality. Well, in which case, Mr. Fadil, having his costs assessed under the indemnity standard, proportionality is not relevant to an indemnity assessment, in which case there should be no reduction in Mr. Fadil's claim. What I'm saying is, in effect, the argument, the answer remains the same as on both calculations. So perhaps I can come back to that in a more considered way. So if we just start at the top left of this diagram, this figure. So we have the gross costs of TIG in the court and the CFI was 455,000. That can be compared to the 370,000, which is in the sort of the pinkish colouring related to Mr. Fadil. So Mr. Fadil's total costs were 81% of TIG's. Okay, so not only was he the winner, but he did it at 80% of the cost of TIG. Not only that, that was several years of Mr. Fadil's costs, whereas we're only looking at a period of just over 1 year of TIG's costs. So he has been faster, better, cheaper. So the next point is, if we simply adopt his honour's reasoning, and it is, we could go through a forensic line-by-line analysis of everything, but it appears that both parties have ended up at this. They've taken 65 and 35 as being good figures to work with, and I respectfully suggest that the registrar adopts that as well. It makes it a great deal easier. I've spent many hours going through the bills, but there's not enough detail perhaps in either bill to make this separation, because at the time the bills were written, the separation was never in contemplation. So it was never in contemplation when when Adelshaw Goddard produced its bills, that some of this would be attributable to the tort claims, and some would be to the employment claims, and so it was. And they have never quite properly, they've never attempted to rewrite their invoices either, by my reading of them. So they've just stuck with the original narratives, and that's the proper approach. So thank you. So
to the point of rest, Mr. Bowden, I won't be separating the two claims.
Right. Thank you. So you're happy with the 65-35?
Yeah. Yes.
Well, okay. Well, I think that Mr. True will probably be happy with that as well. Okay. Well, we say that the answer is pretty simple. Okay. So, and if we go across to, and I'm sorry, they should be. I should have put numbers around the outside, but if we go across to the middle column, the net costs at 35%, that's 159,000. That number is not in dispute, and it's simply the CFI right-hand column of 103,000. So we say that the correct figure for the assessment of TIG's costs in the CFI is in fact 65% of 35. We go for 35 of the gross and reduce that to 65%. The next, and we'll just go, and the same application applies to the Court of Appeal costs, and that is 92,000 being 66%, but that should be assessed on the standard basis, and that is 59,900. And so that therefore their gross costs of $594,000 US reduced down to 163, and over in the pink in Mr. Fadil's columns, we have his gross costs of 370,000, his 65% of that, but he gets to keep 100% of that. Now, if proportionality was, well, there's two ways of applying proportionality here, and that would be, well, the main way would be to say that the first way would be to say, well, if we're going to apply proportionality to TIG's costs, what they should indeed themselves be reduced to 370,000 as a maximum, and they should get 35% of that. That would be another way of addressing it. Sorry, I haven't put that in a table, but that would be another way of addressing it. And if, as TIG have said, and I might, if I may, just go to the TIG submission, because we might as well jump to that now if that's okay. And that's their reply submission, and it's document 4 of their claimant's response to defendants, and that is the document dated, sorry, it's headed claimant's response to defendants' points of dispute.
I have it in the claimants bundle.
Yes, it should be in the claimant's bundle.
Okay. All
Yeah,
right.
not in mine. I've just jumped over here, if I may, to address the point, and can I take you down to paragraph 8, or 7 and 8? So there, TIG also reproduced His Honour Justice Sir Richard Field's part of the judgment from March 2023, and says, I conclude that the outer limit of the proportion of TIG's total reasonable costs represented by the costs dealing with the tort claim is 35%. And then their submission on that reads this: the fact that the court has imposed a 35% on the reasonable costs to be awarded to the claimant is an acceptance that the court considers 35% to be a proportionate level of costs awarded to be awarded to the claimant. If the court had not considered a figure of 35% proportionate, it would have imposed a lower percentage. Well, with respect, that doesn't deal with the indemnity standard argument at all. It simply says that, again, like in the Court of Appeal, it says you had a 35% success rate. But if that is the argument, it works against you, because for the defendant, they have indemnity costs. And as we have seen, the difference between an assessment of standard and indemnity costs is that proportionality is not relevant to the consideration on the assessment of indemnity costs. So therefore, if 35% is a proportionality figure, we should get 100. Okay, so it's not a. So what I am saying is that 35% was not an end figure; it's the figure to be assessed. So in other words, the table that we have been looking at is correct, because proportionality does not arise in the indemnity assessment. Am I making sense here? Right, because the fallacy in what TIG are saying at paragraph 8 is, so where they say the fact that the court has imposed a 35% on reasonable cost to be awarded to the claimant is an acceptance that the court considers 35% to be a proportionate level of cost to be awarded to the claimant. So that's an acceptance that under a standard assessment of cost, proportionality is relevant, and they are saying, well, 35% is the proportionate figure. Well, that's, if that were to be correct, which I'm saying it's not, but the flip side of the coin is that we are entitled to 100%. And so if that argument is correct, we don't have to reduce to 65% at all. We stay at 100 for our assessment. Okay? So both sets of costs remain higher. So if you'll indulge me further, and we can shoot back to the table that we were looking at, and that is document 3 in our bundle, and page 7 of that, the 24 July document. If what I am saying there is that if TIG's argument were to be correct, and they say, so if TIG's argument is correct, the way I read it, is that they retain their net costs. So the middle column is where the assessment stops for them. And they retain their net costs of 159,000 and their net costs of 92,000 in the Court of Appeal, and that they don't have this further reduction. Okay? Well, if that argument is correct, what must equally be correct for us is that we retain our 100% of ours, because proportionality does not count in the assessment of indemnity costs. So that we stay, if they are allowed to stop at the middle column without the further reduction on the right-hand column, in which case we move to the left as well, and we stay with the gross costs. Now, an unfortunate aspect of the way that this went is that there were simultaneous submissions, so a simultaneous filing of the costs claims and a simultaneous filing of the points in response, and a simultaneous filing of the response to that. So I never got a chance to respond to what Mr. True said, and he hasn't had a chance to respond to my last submission either, and that's why I'm doing it orally. But if you wish, I would be happy to resubmit this column, just setting out that. And it would only be an addition of an additional column, or just a reworking of the figures, to say that what we end up with is all of our 370, and well, it's 300. The simple answer to my, so thinking on my feet, the simple answer to my point that I'm making here is that it would be 370,000 to Mr. El Fadil, less the 251, and so it would end up at the middle column 24,374.65 in favour of Mr. El Fadil. So and I'm sorry if there's a confusing way that I've approached it, but what I'm saying is that if TIG is right in their submissions, the net figure for Mr. El Fadil becomes 24,000 US dollars. But that would be wrong for many reasons. It's a wrong approach. This is the right approach, which we're looking at here. It wouldn't reflect the overall success. It wouldn't reflect the reprehensible conduct of TIG, and it wouldn't reflect the proper balance between standard and indemnity costs. Okay, so that's really the answer. For every reason that reasonably arises, 112,000 is an incredibly modest figure for a case that went on over many years, and in respect of which TIG got absolutely hammered, and we've had a look at what the judgment has said about their reprehensible behaviour. So 112,000 is the least that one would expect ever to get away with in a case of this nature. And we've been incredibly generous here. And one area of total generosity by Mr. El Fadil towards TIG in respect of these costs is if we were truly applying proportionality, we would have reduced TIG's costs from 455, from total cost from 455 down to 370, and said, well, if you're proportionate, you shouldn't get any more than us at all. And we should start with sort of equality of arms and give them 35% of that, and then reduce that. But we haven't done that. We've come to a net figure of 112,000 US in favour of Mr. El Fadil, and that is a fair and a just one. Now, the other slight issue, and if I perhaps shouldn't have skipped it, can we just go back up to paragraph 10 of the same submission, just a page up? And I was trying to hurry myself along, but it was perhaps a mistake, just to remind ourselves of the difference in that assessment. So whether on a standard basis, so the standard or indemnity under 38.17, where 38.18, where the amount of costs is to be assessed on the standard basis, the court will only allow costs which are proportionate to the matters in issue. And what I say, that if we were truly applying proportionate costs, they wouldn't get any more than us as a starting figure, and resolve any doubt which it may have as to whether costs were reasonably incurred or reasonable and proportionate in the amount in favour of the paying party. And where costs are to be assessed on an indemnity basis, 38.19, the court will resolve any doubt which it may have as to whether costs were reasonably incurred or were reasonable in amount in favour of the receiving party. So what I'm also, so that is the answer to TIG's submission, which you hear, that if His Honour intended 35% to be the proportionate amount that TIG should receive, well, in which case proportionality does not apply to Mr. El Fadil, and he gets 100% of his costs. Moving over to the left-hand column, which would give him 24,000, but that would be wrong. And so I have very little left to say on that. Do you have any questions, Madam Registrar, about that? I did go into a non-agreed outcome, but perhaps I should take you to that in a minute. But what I would like to do is just look at a couple of easy authorities which back up the difference. What is the difference between standard and standard and indemnity? And under TIG's approach here, there's simply no difference between standard costs and indemnity costs. They say, oh, well, we get what standard costs mean is that we get 35% of our costs on an indemnity basis. That is just simply wrong. So if I might move to a couple of to the authorities which I rely upon, and can I first of all go to A1.1, which is just an extract from the DIFC's own book, or the book of Mr. Montague Smith, indeed, which was published in association with the DIFC courts. And we set out here 38.17.1.
Yeah, I'm with you.
Sorry?
I'm with you, Mr. Bowden.
Oh, thank you. Right. And then I'm looking here at the very bottom paragraph, and this is the Al Kharafi case. Deputy Chief Justice, formerly Lord Justice Chadwick, explained in broad terms that distinction between standard and indemnity bases. Put shortly, on a standard basis, it is for the receiving party to satisfy the court that the costs were claimed were reasonably incurred and reasonable in amount. Whereas on an indemnity basis, it's for the paying parties to satisfy the court that the costs claimed were not reasonably incurred or not reasonable in amount. The burden of proof differs in that in respect and in practice, it is usually found that an award on a standard basis results in an assessment which is some 60% less than that which results from an award on an indemnity basis. So it is a little difficult to follow the language in that last sentence as to is it 60% of or 60% less. But certainly in terms of this case, I am more than happy to follow the approach of saying that it's that 65% being a oft used figure. So I think reading literally 60% less should mean actually 40% of, but that I think would be too low, and we have settled on 65% as being a reasonable one. What if we could go next to its decision A2, and that is the actual decision from that case.
This is the decision made on the 28th of October 2014.
Yes, thank you. And if we just scroll down to paragraph 15 of that decision. Now, interestingly, the wording is different for reasons which I'm not quite clear about. However, what the published decision says something slightly differently, and so I thought I must bring this to your attention. But if we go to the very final sentence in paragraph 15, the burden of proof differs in that respect in the two cases, and in practice is found normally to result in an award on an indemnity basis, which is in some considerable degree higher than an award on a standard basis assessment. So when His Honour Sir Richard Field said that TIG gets 35% of its costs to be assessed by the registrar on a standard basis, he could not have meant anything other than they'll get 35% of the costs, and it will be assessed on a basis which leads to an award which is some considerable degree lower than that on an indemnity basis. My apologies. It could not have meant any other thing. If you follow my learned friend's reasoning, there ends up being no distinction at all between indemnity and standard. And in view of the shocking and horrific facts of this case, that would be very wrong. And when I say shocking and horrific, I don't mean to disparage Mr. True or his legal team in any way, shape or form. That is absolutely not, we're not responsible for our clients. Okay, the very next point which I would wish to address is, I'm sorry, I've lost my own way. If we could just very briefly go to A3, and that is, this is just, it's something from the internet. It's simply an example of, it's an article written, often written by law firms to promote themselves. I'm not putting any great emphasis on it, other than to say that it reflects what is the common understanding. And indeed, it relates to the Australian legislation, Civil Procedure Act. But if we come down to apologize, I had. Are you still there?
Yes.
Can you hear me?
Yes, I can hear you.
Okay, thank you. I seem to have lost my link. Anyway, on page 2 of that document, what is the difference between indemnity and standard, between standard costs and indemnity costs? And it says there, standard costs are necessary for the attainment of justice or for enforcing the rights of a party whose costs are being assessed. Standard costs will be the court's first starting point when costs are being assessed. These typically entitle a party to recover 50 to 66% of actual costs incurred. So that's the basis of standard costs. And above that, indemnity costs means the court will generally exercise its power to order indemnity costs on the basis of contractual agreements. This means that costs incurred, no, I think that what is meant by an indemnity basis, if the parties incurred unnecessarily high expenses during proceedings, that's not us. If the party has made untrue allegations of fraud, that is the case for TIG, and where there's evidence of misconduct by a party leading to the loss, where a party has made baseless allegations and contentions. So I'm wondering, Madam Registrar, did you want me to go into a, if you like, a forensic analysis of the costs claim submitted by the claimant in relation to this matter, or if we are sticking with the 65-35, I'm anticipating that won't be necessary. Am I correct about that?
Yeah, I don't think it's necessary, Mr. Fadil.
Okay, thank you. Well, if I may, I'll finish my submissions there and perhaps reply if it's necessary to Mr. True. Thank you.
Thank you, Mr. Fadil. Mr. True?
Thank you, Madam Registrar. Thank you to my learned friend for that. Madam Registrar, you'll be pleased to know that I don't intend to regale you with as much information as my learned friend did there. You'll also be hopefully pleased to know that, in fact, there are a number of points on which we agree. And so if I can just briefly run through where it is that we agree and perhaps the fundamental points on which we differ, then that would allow us to move forward quite swiftly. My learned friend, of course, took us through the difference between indemnity and standard basis cost in great detail there, which we appreciate. And there is no dispute from our perspective that Mr. Fadil, the defendant, received his costs on an indemnity basis. And there is no dispute that the claimant, received their costs on a standard basis. I think perhaps where it is worth clarifying, and perhaps just to reiterate, is that the indemnity basis requires reasonableness in regard of their costs, and a standard basis requires both reasonableness and proportionality. Now, my learned friend is absolutely correct when he takes you to the relevant paragraph 8 of our points of dispute, or sorry, reply to the points of dispute, in which we set out, hopefully quite clearly, that we say that by capping the costs at 35%, the trial judge and my reasonable friend has made great stock throughout this process that it is the trial judge who has great knowledge of the matter and the issues in question and is in a position to make those sort of decisions. It was the trial judge that set the costs at 35%. Now, he, of course, and he being, sorry, the court judge, had full knowledge of the proportionality of the costs that were being incurred by the parties. The group, the defendant, so the claimant had a KC. It had, if I say so myself, a reputable law firm, international standing, which I don't believe is in dispute, acting for them. And we say that the reason that the costs were capped at 35% is because the trial judge, the court judge, had that knowledge with regards to the proportionality of what costs should be incurred. Where the court judge was not in possession of is the reasonableness of the costs that have been incurred, because he did not have access to either party's bill of costs. So he was not aware, as an example, of whether or not our costs had been incurred in a largely inflated manner by spending hundreds of hours on one witness statement. He was not aware as to who had undertaken the majority of the work. Was it a partner? Was it a managing associate? Was it a paralegal? He did not have that information. Therefore, that is why he set out very clearly, I conclude that the outer limit of the proportion of TIG's total reasonable costs represented by the costs dealing with the tort claims is 35%. And I would suggest that, respectfully suggest to you, Madam Registrar, that that is very clear language with regards to how the court judge wanted to approach this. And that is, the proportionality is set, and my learned friend is absolutely right, that from a proportionality perspective, that does not apply to the defendant's costs, Mr. Fadil's costs, as it was on an indemnity basis. However, where I differ from my learned friend is he suggests that that automatically means that he is entitled to 100% of his costs. And I dispute that, because there is still a requirement under the RDC that any costs incurred on an indemnity basis are still reasonable and reasonably incurred. Madam Registrar, you said that you had read the documents, and I therefore don't propose to take you line by line, although it may subsequently prove necessary. But we have set out in our points of dispute, again, hopefully quite clearly, where we say that the costs that have been incurred by the defendant, by Mr. Fadil, are not reasonable. There is no reference to proportionality within our points of dispute, for the reason that they are an indemnity costs. However, we do take, in some cases, great disputes with the reasonableness of some of the costs incurred. And it may be that we come back to that at a later point if you feel that that would be necessary. I do think it's perhaps just worth noting that my learned friend took you to the Al-Kharafi case that was referenced under 38.17 of the RDC. And he is, of course, absolutely correct where he said, the burden of proof differs, and in practice, it is usually found that an award on a standard basis results in assessment which is some 60% less than that which results from an award on an indemnity basis. And I would in fact agree with my learned friend there as well, that perhaps the 60% less, I'm not sure I necessarily agree with, but it is agreed that the standard basis is a lower figure than the indemnity basis. Again, I would say that by the fact that the court has actually capped the claimant's costs at 35%, that assessment has already been taking place. And there is nothing about the suggestion that 35% is the amount that should be accrued and paid is in fact, it contradicts in any way the case of Al-Kharafi. So I would suggest perhaps that the position is actually very simple across all three aspects of this claim. And by three, I mean the claimant's costs for CFI, the claimant's costs for the Court of Appeal, and the defendant's costs for the CFI. And if I can just very briefly summarise for you, Madam Registrar, I would suggest that with regards to the claimant's costs for the CFI, those costs are capped at 35%, which is agreed. And it is for my learned friend and for yourself to then review those costs and consider their reasonableness. And it is at that point that perhaps the 35% would be reduced if you reviewed our bill of costs and considered that any of the entries in there, any of the time recording, was unreasonably incurred. And for exactly the same point, I would suggest that with regards to the Court of Appeal, the reference is that for the claimant, the costs are capped at 66.6%, 2/3. And I would say that, again, that is based around, it is for my learned friend to draw your attention to our bill of costs and to say which are reasonable and which have been unreasonably incurred. And again, I would just reiterate that from our perspective, and I'm of course in your hands, reasonableness goes to whether or not, for example, 100 hours has been spent on a witness statement by a partner rather than a trainee or a managing associate producing it in a much shorter period of time. That is where reasonableness comes into play. And just finally, on that third point, with regards to the defendant's Court of Appeal point, again, as I say, my learned friend makes great stock of, well, if we are taking proportionality out, they must automatically receive 100% of their costs. And I would respectfully say that that is not correct on the face of it, or indeed under the rules of the Dubai courts, because there is still the reasonable test that needs to be applied to those costs. And notwithstanding any dispute that we may have over the quality of the narratives that have been provided, and I do have sympathy with my learned friend that a lot of the narratives are not in his gift to have amended, but the quality of the narratives that have been provided, we would suggest there are a number of issues there with regards to the reasonableness of some of those costs. And if I can just take you for an example, the reference to fees that do not form part of the costs of the claim in respect of room hire, fees paid to a public prosecutor as part of a criminal proceedings, fees paid to a partner within a law firm who seemingly had absolutely no involvement whatsoever but received 15 hours worth of time. We would say that this goes directly to the reasonableness of whether or not those costs should be awarded, not the proportionality. Now, we would be arguing proportionality on a standard basis, but we accept that the costs are indemnity. And that really is as far as I feel as though I need to take you at this point, Madam Registrar. It may be that if you're in agreement, that we then go into a more deep dive of exactly what costs have been incurred by both parties via our respective bill of costs. It may be that you say we are just going to leave it at a 65-35 split. I'm of course in your hands there, and it may be that my learned friend has some comments on my interpretation of reasonableness and proportionality, but unless I can assist you further, I don't propose actually taking you in any further detail.
Right, thank you very much, Mr. True. Mr. Bowden, would you like to
Yes, I do have a brief response to that. If we go back to my learned friend's paragraph 8 of his final reply submission, and what the judge said there, I conclude that the outer limit of the proportion of TIG's total reasonable costs are represented by the costs dealing with the tort claims as 35%. So although both parties, and I respectfully say it's a sensible approach, and I think you've indicated you're going to take it, although both parties have said, okay, 35-65, fine, we can, we're simple people and we can do those numbers ourselves, and that's great, and it leads to a tidy result. But if my learned friend can't have his cake and eat it, if he wants to go behind those numbers, well, here's the answer. And if we go to my learned friend's claimant bill of cost CFI, so that's the first, it should be the first document I'm hoping it is bundled, and it is 41 pages long.
Mm-hmm.
Okay, and so although we've elected to treat it as a 35-65%, what his honour was in fact saying was, well, I don't believe that you spent any more than 35% of this case on this, and that the outer limit. So he wasn't determining the point. We have accepted that as a good figure to go with, but if my learned friend wants to go behind that reasoning, well, what his honour said was the outer limit, by which he must have meant it can't be any more than, and the precise figure needs to be assessed. And if we, can I invite you to do this? I'm sure you can. Right click or go Control F, I think it is, and type in the word malicious. And what that will do for us is determine, well, you can do this yourself, but there are, in the entire bill for the CFI presented by my learned Adelshaw Goddard, there are 4 references to malicious. And so if we were, and perhaps if you've got a pen handy, Madam Registrar, can I ask you to do this? And that is that I've added up council's bills, and they're at items 13, 17, 29, and 52. So, in fact, we could just have a look at those starters. So if we go down the left-hand side of see on the left-hand side of this bill, it helpfully it has numbers. The first one we come to, and that is on page 9, is 13 brief fee to council, first tranche one. You see $23,968. This is all in US dollars. The next one we come to is 17, and that is brief fee to council, tranche 2, 23,500. And the next one is number 29, and that is, and I can provide these figures in a brief email if you want. I've worked them out. Next one's 29, which is 54,902, brief fee, third tranche, and then we have down at 52 the fourth tranche, and that is for brief fee 54,902. Now, that adds up to 157,422.00. 35% of that is $55,097. So let's make the assumption, because we don't know anything of what happened behind those brief fees. There's no further detail about council's fee than that. So let's make the assumption that that was 35% of Mr. Montague Smith's time was indeed spent on this. Okay. And then we looked for what other evidence in the bill relates to this malicious prosecution or indeed abuse of process. and we see 4, and they are, the first one is, it's on page 30 of the bill, and that's, should be a toggle on the right somewhere where you can quickly flick to page 30. And that is 1, 2, 3 lines down. So that's Mr. Brown. He's spending 18 minutes there looking at the issue of malicious prosecution. At his charge out rate, that is $690 per hour. So he spent $230 there. The next one we come to is on page 37 of the bill. You can do it either Control F or just toggle down, and that is Mr. True, and this was shortly before trial, preparing for trials, drafting tables relating to payment list and the succeeder report, preparing to meet Mr. Jabra and Mr. Zaglu, reviewing malicious prosecution and considering the UAE penal code. So a number of activities in that 7-hour period, it's presumably a full day's work. And if we assess that 3 hours of, just under half of that time was 35%, and indeed of that time was applied to malicious prosecution, that would give 3 hours, and that's 1,300. Sorry?
Did it come across clearly?
Mr. True, Mr. True, you might need to mute. That would be $1,350 of Mr. True's time if we gave him 3 hours for that. The next one, and I'm not suggesting this is helpful. What I'm suggesting is that this takes Mr. True's submissions and puts them into effect. If we really are doing what he says should be done here and undergoing an analysis of the bills, this is where we get to. The next one is on page 38, 24th of August 2021, and that is work on witness bundles, discussions with David True, considering malicious prosecution for client. Now, this is a paralegal. Now, if we talk about people who are unknown to the case, well, here's one with respect right here, Miss Sumaya Dajani. But at her charge out rate of $210 per hour, and we give her 1 hour for work considering malicious prosecution, that's another $210. And the last one is at the 1st of July, and sorry, this is at page 11 of the bill. Should have probably been the first one. If we go to page 11 of the bill, and it's right at the bottom of that page. And you see first 1/7/21, long email to Mr. Jabera and Mr. Zaglu, read disclosure of documents, the allegation of malicious prosecution and the abusive process, reporting on counsel's advice and strategy moving forward. We've got another 18 minutes there. So that's it. So I'd actually given him an hour for that, because it did say 5 long emails, and I didn't see that it was just 18 minutes, but it said engaged 4 hours and 12 minutes. And so I gave him an hour for that. So if we add all of those times up, that's another $1,480 US. So if we were to engage upon forensic analysis of TIG's accounts, what we end up with is 35% of Mr. Montague Smith's time. That's $55,097, to which can be added $1,480 worth of Adelshaw Goddard's time. Now, that's the analysis. If we're going to do an analysis, that's where we get to. So those two figures, it's 57,000. So that would reduce considerably the claim. Now, there's lies, damn lies, and statistics, and this is really an example of it. Surely they spent more time than 4.5 hours on the issue of malicious prosecution, right? I accept that they did, but there's simply no evidence of it in their bill. And in one way, that's to the credit of Adelshaw Goddard, that they didn't go back and try and reinvent the wheel in an ex post facto manner and say, oh, we could have spent some time here, we could have spent some time there. They haven't done it. So there's simply no evidence. So the 65-35 split is appropriate, but unless there is a further reduction, we simply don't have any difference between indemnity and standard, and that would be wrong. Okay. Just regarding the other objections, I put in a relatively lengthy response to all of the points of dispute which had been raised by TIG, and that document is to be found it is four in our bundle. My apologies. Attachments to it. And how I did that was by reproducing their bill of costs, converting it to Word, and then inserting in blue a comprehensive reply to each and every objection. Regrettably, and it's no fault of Mr. True's, but Adelshaw Goddard is the 6th lawyers that have been engaged by TIG in relation to this dispute. And it appears that they had their own disputes with each and every one of the previous 5. The consequence of which was that they didn't have the files, and nor did they have the bills. And they were unaware, of course, that most of what they were objecting to had in fact been paid by the earlier lawyers. So all of those objections are moot, and that's listed here. So you can't object to costs which have already been paid. Your time for objecting to them was before they were paid. The next point is this, is that the fees paid to the public prosecutor, well, of course, they were part and parcel. I mean, I'm sure you've read the original decision, and the whole deceit which TIG entered into was to get Mr. Fadil prosecuted for fraud, something that they very nearly achieved. And the HPA report was an integral part of it. So of course it's a reasonable disbursement to charge for that. And as regards the billing, the time, the room hire, well, that is also a reasonable disbursement, and I provided in the annexures there's evidence which relates to that as well, as best that I could find. But I'm inviting the court in relation to if you're going to have a remote hearing, it has to be held somewhere, and suitable rooms have to be found, and sometimes they have to be hired. And in this case, it was. And the room was hired, the boardroom was hired from Bindahi, and that is where the hearing was conducted. And also with respect to Mr. Alasili's 15 hours, well, he's the managing partner of the instructing solicitors. not only that, but he was the first lawyer to act for Mr. Fadil in these proceedings. So of 15 hours, he didn't have to do all of the work, but it was his job to maintain a watching brief over this. My learned friend will know that he was copied into many, many emails, the majority of emails, apart from those simply dealing with mechanical matters relating to the hearing. That is perfectly reasonable. And just as Mr. True and Mr. Brown were both in attendance throughout the entire hearing, so was it reasonable to have Mr. Omar Ramadan also in attendance to the hearing. Mr. True didn't appear on camera. Mr. Brown didn't appear on camera. They were there. The various interns were also there. They have charged their time where they were applying to it, and so was Mr. Ramadan. And it's necessary to have. You simply can't do a big, tough hearing all by yourself. It's just not possible. Somebody has to be out there organising things, fetching, carrying, getting witnesses, and so that's a reason. I don't have any other submissions other than to say that diving down the rabbit hole, well, my learned friend, he can't have his cake and eat it, with the greatest respect to him, and diving down the rabbit hole into the minutiae of these bills doesn't work. What is best is a broad brush approach. The defendants, the successful defendant who got indemnity costs, his overall costs were 80% of the losers. We haven't taken off any points for that, but what we are entitled to is the indemnity. Thank you. I've nothing further to say, other than to say that I have put in our cost of costs, and if you wish me to follow up with a brief email which sets out the total cost sought, they are the original 1,014,000 in the notice of commencement, the 76,000 which has been paid by Mr. Fadil in filing fees, and sorry, that is at document 1.1, and also the costs of costs which are at document 5, and the total amount is 1,232,908.85 dirhams. But if you wish me to confirm that in an email, I'm happy to do so.
That would be helpful. All right. Mr. True, anything you would like to say in response very briefly?
Thank you, Madam Registrar. I certainly don't want to get into a ping pong back and forth. 2 points, really. Firstly, I feel as though, whether unwittingly or otherwise, my learned friend, in fact, proved the point I was making around proportionality, and that was it is entirely not possible to go through both sets of bill of costs and accurately proportion which part of the costs was based on abuse, the malicious prosecution and abuse of process, the torts, as they were claimed, and the employment split. Certainly, I wasn't suggesting that we do a Control F search of either sets of bill of costs to decide whether or not malicious prosecution was considered in less than 4 hours over the course of the proceedings. In fact, I think what he did do was demonstrate that by the court saying that the costs would be split to 35% to 65%, that was in fact the trial judge, who had full knowledge of it, expressly setting out what the proportionate split was between employment and torts. And I appreciate him saying that he agrees that there was more than 4 hours spent, which in fact goes, as I say, to prove my point. Secondly, and this was a point that perhaps came up, you will note, hopefully, that the bill of costs provided on behalf of the claimant are very clear. They're set out in a standard bill of costs format. It is very obvious what each narrative relates to throughout the entire proceedings. Unfortunately, the defendant's bill of costs consists of various invoices and almost one-word narratives and we have done our best to interpret that as far as we can. Now, my learned friend made reference to the fact that a number had already been paid and were actually dealt with in proceedings not relevant to this. And on that point, and I did raise this in our points of dispute, I query why on earth they were involved or included at all, because at best that is just causing confusion to have included narratives for matters that had already been dealt with and had already been paid off. So if we are considering the costs of the costs, my concern would be that the approach taken by the defendant has led to an unnecessary level of costs on the claimant's behalf, trying to interpret what that so-called bill of costs actually related to. Again, Madam Registrar, if I can be of any more assistance, I'm more than happy to, but I don't want to be involved in a ping-pong battle over this point.
Thank you very much. I think I have everything I need. Thank you very much, gentlemen. I haven't seen any bill of costs for today's hearing. Will that be put in at a separate point in time?
I had kind of included that in my costs of costs under point
Costs of what?
5. If you're happy with that, I anticipated what the costs might be.
Mr. Bowden, can we have this in a bill of costs? So the
Yes.
form on the e-registry, if possible.
Yes, yes. I'll attend to that today.
Okay.
Might I then also simply send an email, because that'll change the total amount sought. So the 1 million wouldn't change, the 76,000 wouldn't change, but I had, on my cost of cost, I had it at 142,000. If we go for actual costs, and the time that we've spent 1.5 hours here today, it would slightly change the figure, and I'll do that. I'll part of the curse of being a Part 2 practitioner is that I have no visibility on the court system, and so I'm very dependent upon Mr. Abdullah at Bandahi. I'll try and contact him today and do that. If I'm unable to do so, might I have it till tomorrow to complete that?
Yeah, that's fine. Tomorrow is reasonable. Mr. True?
Yes, Madam Registrar, we'd be happy to provide a bill of costs. Would it be, if it would be helpful for it to be in the level of detail of the 2 bill of costs that we have previously provided, then I would say that perhaps that we may need more than till tomorrow to provide that, because that's obviously quite a detailed document and is in a set format. If it is as simple as just providing the figure and perhaps some narratives in the manner that the defendant has done, then that of course is something that we can do much quicker.
I would be more than happy with the simple statement of costs form that's on. It is signed by Statement of Truth, so I would be fine with that.
The online statement of costs form.
Yeah.
P, whatever it is. Thank you.
Yeah, I think it's P4001, something like that. All right. Thank you very much, gentlemen.
Thank you,
Madam Registrar.
Thank you, Mr. True.
Thank you, Mr. Bowden.